Just so that you know, this is the post-Horizon issues judgment contract. We'll come back to it later today or perhaps tomorrow for some other features of the contract. Can we look at it in relation to what postmasters are told about investigations of them now, however, by looking at pages 71 and 72. This is section 19 of the new sub-postmaster contract, and it concerns in broad terms offences committed by sub-postmasters, their suspension and inquiries by officers of the investigation division. You can see that that's the heading underneath section 19. You can just scan, if we go down slowly, so you can see the context of what is going to be said on page 72. Arrest and conviction, immorality, suspension. Then we scroll on, please. Criminal conduct reporting, inducement to act contrary to the rules. And then over the page. Thefts by strangers, failures to report dishonesty. And then the cross-heading, inquiries by officers of the Post Office Investigation Division, POID, as it used to be known for many, many years. And it says, as sub-postmasters are told, the main job of the investigation division is to investigate or help the police to investigate criminal offences against the Post Office and others. The investigation division does not inquire into matters where crime is not suspected. Most of the crimes dealt with by the investigation division are committed by outsiders. It follows a common reason for investigation division officers seeking interviews with persons employed is to get help in clearing up such offences. And then this, paragraph 14, although they comprise the minority of all investigation division crime investigations, there are many cases where the possibility or even direct suspicion arises that persons employed by post office business may be involved. Officers of the investigation division conduct interviews about these suspected offences, and they're required to observe the same code of conduct when obtaining evidence as that laid down for police officers. This provides for an officer investigating a criminal offence to question any person, whether suspected or not, from whom he thinks that useful information may be obtained. As soon as the investigation division officer has evidence which would afford reasonable grounds for suspecting a person has committed an offence, he must caution him before asking any questions about that offence. The caution must be in terms which make it clear the suspected person is not obliged to say anything unless he wishes to do so, etc. And then 15, if a sub-postmaster or post office branch assistant is questioned as a suspected person by an officer of the investigation division on statements made by a third person and expresses a desire to be confronted by that person, such confrontation will, if practicable, be arranged. At the confrontation, the suspect will be at liberty to question the third person on his evidence, and the questions and replies will be recorded by the investigation division officer. So this describes those conducting the investigation as the Post Office Investigation Division and officers of the investigation division. Given the history of the scandal dealt with in the judgments of Mr. Justice Fraser and the Court of Appeal Criminal Division, and indeed perhaps the inquiry, is it appropriate that Post Office maintains within the contract the existence of the Post Office Investigation Division?
I must say, I think the wording is heavy-handed in terms of the way it's described. and I don't think it reflects the way that we conduct investigations. So I think there is a misalignment, and the expression investigation division is not consistent with AC&I. So I would agree with you on that.
And again, given the history, is it appropriate that the sub-postmasters are told that the investigation division retains investigative powers that include an evidential interview process under caution?
No, I don't think it is.
So at least this section of the contract requires some quite radical revision properly to describe the system for reporting an investigation of possible offences by Post Office to the police, doesn't it?
I would agree.
Do you know why sub-postmasters are told this? Admittedly, on the basis of the inquiry survey, only 15% have got the new contract. But,
yes.
Why sub-postmasters are told this sort of 5 years on after the judgments of the High Court?
I would agree with you that it's not consistent with the way that the AC&I team operate. It's not consistent with the way that we conduct investigations in practice, and it's not consistent with the way that we support postmasters when they have issues. So I think there is a misalignment. I would agree with you, Mr. Bear.
And from a postmaster reading the contract, nothing has changed, has it?
This would not, as you say, the language and the way that it's constructed is not helpful and not reflective of the way the Post Office is operating today.
And so that raises the why question.
Yes,
why is it still like this?
No, and I think that's an entirely reasonable question. There is, we've obviously done some work on contract restatement. We've obviously done some work on addressing the issues that have emerged from the CIJ and the HIJ, and made sure that the core tenets of that particular judgment, particularly the duty of good faith, and particularly the presumption of innocence, and particularly the addressing issues around secrecy and lack of transparency, I think it would be entirely reasonable to conclude that this section of the contract needs rewording, and it needs addressing, not just rewording, but it needs addressing. We're clear that we have work to do on contracts in terms of the specifics, and I would say that back in 2019, once we had the judgments handed down, the most important element for me at that stage was to make sure that we changed the behaviours within the organisation, and then we changed the contract. So, which is why we did a restatement rather than a recontracting completely across the organisation. That is still outstanding, and that is work that needs to be done.